Calling to order tonight's Policy Review Committee meeting. The date is November 28th, 2023, and the time is 5 p.m. We will start right off. There are no new policies, so we'll start with policies with changes, starting off with Policy 413, Harassment and Violence, with Dr. Chris Belmont. Welcome, Dr. Belmont.
Thank you. Good evening, Board, Policy Committee. For 413, Harassment and Violence, there are some definition changes from the School Board Association. So just around the definition of sexual orientation, just direct the committee to Section 3 definitions, D6, where they have listed a new definition that we're recommending adoption. Sexual orientation means to whom someone is or is perceived of as being emotionally, physically, or sexually attracted to based on sex or gender identity. A person may be attracted to men, women, both, neither, or to people who are gender queer, androgynous, or have other gender identities. That should complete the change recommendations in 14. Maybe some references as well. So
It's based on
the latest legislative changes in statute. Yes.
All right. Thank you very much.
Yeah, thank you.
Committee members, any questions or comments?
That was going to be my only qualification, is just that this language is, we're drawing this directly from legislative changes and or MSBA recommendations used throughout the state, correct?
Yes.
There's nothing specific we did here that unique or anything.
It was changes to state law, specifically Minnesota statutes, section 121A.03. And then MSBA translated those law changes with these recommendations.
Thank you.
Gotcha. Any questions? No? Nope. All right. So that policy 413, will be a first reading.
First reading, okay.
And we will move on next to policy 416, drug and alcohol testing, staying with Dr. Belmont.
Yeah, thank you, Director Alt. This policy 416 also underwent fairly significant changes and specific to the latest cannabis legislative changes last session from the Minnesota statute. Most of it has to do with the rights of the school district to test, to discipline according to even as a result of the cannabis changes on the state level. The changes include the title as well as just various references throughout the policy definitions. And then some.
It's quite extensive.
Any questions on that?
I just want to make sure you were done. Okay.
Yes, sorry.
No,
Sending it
that's
back to
okay.
you.
No, that's okay. Questions or comments, committee members?
I guess the same real question again is just that this is all language derived and driven by either state or MSBA interpretation of state changes, correct?
Yes, that's correct. It does make some clarifications that go beyond federal law because of our latest state changes.
And it speaks of flower and cannabis products, so I assume this would encompass these new hemp or THC drinks, correct? Or any kind of edible for that matter? Is that, I would assume so.
The beverages.
The beverages.
That's a whole new market opening up pretty rapidly.
Yes.
So.
We will get back to you on that.
Okay.
I admit, reading this, I learned more
And-
about cannabis than I wanted
Yeah.
to. But
And it
that
speaks of
detail,
lower potency hemp edible or hemp, so it's just I mean, this isn't a really question, it's just a commentary. And then again, I know it's state level conversation, so it's really not ours to even debate, but it's just, this is such a fractured market now. I mean, things are so, I mean, feels like someone could accidentally consume something without even realizing they were consuming such a thing, so. But anyway, regardless.
any questions, we'll get back. to
Yeah.
you. Specifically, as you know, it's, you use the word fractured, it's still evolving, how this
Yeah.
is all going to roll out in the state too. So,
Yeah, definitely.
Yeah, maybe checking in on section 2D, that first sentence, the use, possession, sale, purchase, transfer, dispensing of any drugs or cannabis not medically prescribed, et cetera, is prohibited on school district property. Maybe that. So we can ask if beverages are included in that definition.
Yep, good question. Do you have any questions? No?
it's
All
under
right.
G, that hemp.
Okay.
So we'll have this come back to us just on the drink question?
Yeah.
Okay,
Yes.
great. So next, we will move to policy 506, student discipline, with Dr. Belmont.
So the MSBA did suggest a slight alteration to policy 506, and it centered around the legislative changes in the ongoing interpretation of kindergarten through third grade suspensions. They just recommended some clarifying language in what to get at the core, the essence of the legislation that says if a student is dismissed for less than one school day, it's not necessarily to meet that definition of suspension. I think I would direct you to D, suspension procedures, number 4, 506-15. The definition of suspension under Minnesota statutes, section 121A.41, subdivision 10, does not apply to a student's dismissal from school for less than one school day, except as provided under federal law for a student with disability. Our principals have been engaged since this legislation came out in procedures, so this just kind of clarifies things that we already were operating under, just in case. So, there's so much, there's quite a bit of questions around that kindergarten through third grade suspension, so I know MSBA is working still on how to interpret all of that.
Gotcha. Any questions?
No.
Just a clarification. So the statutory language has been out for a while. Just making policy match practice and the fact that the student being out of school doesn't necessarily mean that they've been suspended. Is that correct?
If they're dismissed for one.
If they're dismissed for
less
one
than
day.
1 day, so.
Okay.
What we do from a procedural standpoint is we're still working with the family, is we're still documenting it. Some of it really isn't too different, except for technically under the People Fair Dismissal Act, it doesn't qualify as a suspension. So.
And then once they hit fourth grade, there's a broader range of things to consider.
Not really. It's because of, so once they hit fourth grade, the statute around the kindergarten through third grade suspensions no longer pertains to the students. So this clarification actually is just, it's procedurally applicable to all age levels.
Got it.
Okay. I think that.
Thank you. All right, so policy 506 will be a first reading.
Okay, thank you.
Yeah, thank you. And next, we'll go to policy 507, corporal punishment, and Dr. Belmont.
the board might be aware that this is also a policy getting a lot of attention right now, and then the MSBA, the School Boards Association came out with additional language to support the two opinions from the Attorney General that occurred this fall. So you'll see changes in the legal references as well as added language under exceptions where they just name other school staff, and then in prohibitions so under 507.2, they general statement of policy, they direct except as provided below, and then they've added increased language. Shall not use prone or compressive restraint except that the restrictions on prone and compressive restraints do not apply under the circumstances enumerated in Minnesota statutes, section 609-06, subdivision 1. All peace officers, including those who are school resource officers or otherwise agents of a school district, may use force as reasonably necessary to carry out official duties, including but not limited to making arrests and enforcing orders of the court. So, and then the legal references at the end, you'll direct the board's attention to those the Attorney General 169F, first on August 22nd, 2023, titled School Pupils Discipline, and then the second letter, September 20th, 2023, the same title. So, any questions?
Just a curiosity, this is the first time I've seen the word compressive restraint. There's always the prone. Has that always been part? Do we happen to know if that was always part of the language, or?
From his opinions, I believe.
It's what?
It's, Attorney General.
That's additional with the new
I think
view?
it's directly
Okay.
from his opinions, but we'll double check.
That's fine, I just curiosity.
The statute refers to restricting breathing, or
Yeah.
maybe kind of spells out what compressive restraint means.
And prone, yeah, prone is definitely part of it.
And my understanding is too that it's a more known law enforcement term, or more known.
Yeah, I think the original, we went over this originally, didn't we? Yeah, I think the original policy that we had simply just said, you won't make them prone. I mean, I'm paraphrasing it, which seems silly because there's a million ways you could end up with somebody prone, and not all of them had to be restraining necessarily. So this is far more comprehensive, I would say, inclusive. All right.
I just have a question too. On the exceptions where it says a teacher, school principal, and other school staff may use reasonable force under the conditions set forth in policy 506. Is other staff, is it defined further anywhere?
It's a good question. I do believe.
And I can give you an
That is-
example while he's looking up. So
Yeah.
at the last board meeting, I shared that I increased the number of staff that receive safety care 3 training to intervene in fights. So it's not what we would teach, but to me, I think that's the intention of the other staff. There are other staff who are trained that may, but we don't use prone restraints.
So it's going to
So
be
let me clear.
limited to those that have the training?
Well, I'm giving our example.
Okay.
That we may have other staff that will intervene in a fight, but we don't use the prone restraint. So I don't think they specify.
Well, if you cross-reference, because it is kind of confusing when you cross-reference to another
Other
policy.
school personnel.
They define it we define it in our policy 506. All school district personnel shall be responsible for contributing to the atmosphere of mutual respect within the school. Their responsibilities relating to student behavior shall be as authorized and directed by the superintendent. A school employee, school bus driver, other agent of a school district, in exercising his or her lawful authority may use reasonable force when it is necessary under the circumstances to restrain a student to prevent bodily harm or death to the student or another. They then list in 506 other roles within our community, like students, parents, or legal guardians, community members. teachers, principal, superintendents.
Sounds good, thank you.
Yeah, thank you. I've learned a lot about 506 in the last 6 months.
I can imagine, start to finish.
Sometimes just in the middle of the night, that number comes into my brain.
Not that this question is necessarily going to hold things up, and I wish I had thought of this sooner to be able to ask it, but knowing that there are, two parallel conversations, we're having our conversation in policy, and obviously, we have our partners in the city that are concerned about, state law and getting clarification. Did you happen to, and certainly not that our work in the district is going to be determined in any way by our partners in the city, but certainly getting, having perhaps the city manager look at the policy and say, is this, obviously this language is still going to need clarification, I guess, for them, I guess is my question. Did we happen to do that?
So not with the city manager. I don't know if you've had discussion with
Or with anyone at the city, maybe not necessarily the city manager?
Yeah, the contacts in Burnsville police, the contacts that I've worked with have confirmed that they've reviewed through their attorneys, the Attorney General's opinions that have come out. So that's where this language came from.
And then based on that, they still need clarification from the legislature.
So it's fair to assume. Got it. Okay.
I'm not sure though, yeah.
Yeah. Got it. Thank you. All right. So this policy will also be a first reading.
Okay.
So next, we'll go to, looks like our last policy, 620, credit for learning. And Dr. Belmont.
Yes. You get all of me tonight. The credit for learning policy 620 is just an additional reference to increase clarity. So they included in definitions section 3B, concurrent enrollment means non-sectarian courses in which an eligible pupil under Minnesota statute section 124D.095. So my understanding and talking with Director Oftedal is as legislation was more, it codified more policy last spring, it's adding that section, or that reference to this policy 620.
Awesome. Thank you. Questions? No. All right. Policy 620 will go on consent.
Okay.
And with that, unless you need anything, Sarah, do you have what you need from us? All right. So we will be adjourned. Thank you, everybody.
Thank you. Have a great night.
All right, thanks, Chris.
Thank you.
And thank you, Sarah. That's it, because only Aaron and I stay for legislature. I will send you a couple of things.